Welcome back to another edition of Disability Insurance Law TV. My name is Gregory Dell, and I'm a long-term disability insurance attorney. Today I'm joined by attorney Cesar Gavidia and attorney Stephen Jessup. We work with the law firm of attorneys Dell and Schaefer, and in today's episode we are going to discuss the Prudential Insurance Company. We do these videos on a weekly basis to give you an idea of the way that these long-term disability insurance companies are handling your long-term disability claim. In anticipation of today's video, I did a little bit of research on Prudential Insurance Company so that you could have an idea of how big of a company Prudential is. Prudential is what they claim to be the second largest group insurance company in the entire world. They currently have over 42,000 employees. Their revenues last year were $32.688 billion. So that's $32,688 million in revenues. And just recently in the last quarter, their profits were $697 million. Now, Prudential does all kinds of insurance products, but more specifically, just last quarter, their group insurance division, which includes long-term disability, had $53 million in profit. So Prudential is a very large and very powerful disability insurance company. Now, to prepare for today, we've pulled some specific cases around the country regarding Prudential, and we're also going to talk to you about some of our own cases that we've handled against Prudential, including a pending class action that we recently filed against Prudential. But I want to start first with Cesar Gavidia, who I think you're going to talk about a recent case in which there was a substantial verdict against Prudential for their wrongful handling of a long-term disability claim.
Yes. This particular case involved a project manager who worked in this construction department of the University of California, San Francisco, and she had developed chronic fatigue syndrome, lupus, and fibromyalgia, and had filed a disability claim with Prudential. Well, Prudential approved her for about 6 years and then terminated her benefits. They also denied all levels of appeal that she tried to execute. The plaintiff in this particular case then sued Prudential for breach of contract and bad faith, alleging that the insurance company wrongfully terminated her benefits. And you see this particular thing very rarely. She also sued the independent company that set up the IMEs for Prudential and sued the IME doctor. Well, the jury found that Prudential not only breached the contract but acted in bad faith, awarded about almost $15 million in back benefits, punitive damages, and other damages as well. What they were really, I think, intensified over was the fact that Prudential never contacted her friends, her family, any of her co-workers to get any of the information about her condition or daily activities, and they just denied the claim based off of this purported independent medical doctor who just gave them the opinion they wanted to hear.
And you said that this jury was able to award $15 million?
Well, they awarded $15 million, but then later on the appeals court knocked it down to $4 million in punitive damages. They let stand some of the attorney's fees, they let stand the back benefits that she was paid, but either way, it was, I think, a big wake-up call to Prudential.
Right. And Prudential always writes group disability insurance policies, but if this particular claim went to a jury trial and most of their claims are governed by ERISA, how did that happen?
Well, this particular claimant worked for, as I said, the University of California, which is a state-run university. Under ERISA, there are certain types of disability plans that are exempt. For instance, any governmental entities, any church plans, any plans that are self-funded from the general assets of the company. Those are the type that are exempted from ERISA, and you could actually bring state law causes of actions for them.
Okay, so if the particular claim that you're talking about was governed by ERISA, then there would be no ability to bring a claim for punitive damages or bad faith.
Right, you wouldn't be able to bring, aside from perhaps a claim for attorney's fees that is granted within the court's discretion. They may decide to do it and they may decide not to award it. You can't bring any of the other bad faith causes of action or any of those things.
All right, well, I certainly hope that $15 million sent a message to Prudential that their wrongful terminations won't be tolerated. Steve, what kind of case did you come across?
You know, it's funny, like Cesar and a lot of calls that we do take, I found a case here. A person insured was a floors person for the Mohegan Sun Casino, and it was another case of fibromyalgia and chronic fatigue, this one happening out of Connecticut. Of course, Prudential shoots down the case saying there's no objective evidence of the condition. And that's one of the things that the insurance companies, you'll see a lot, Prudential, especially with subjective. They say it's all subjective complaint of the insured that you can't verify. Interesting here, and it gives maybe a little glimmer of hope for people in Connecticut, the Second Circuit Federal District. This is actually really favorable here, where the court comes out and says, because fibromyalgia does not outwardly manifest itself, it would be unreasonable to require objective evidence to support a diagnosis of fibromyalgia. However, the court even goes so far, and as people suffering from fibromyalgia will know, the trigger point test, where the doctor is going to check 18 certain points on your body. They said here for the Second Circuit Federal Court that trigger point testing, if you come up with 11 of the 18, is concrete proof. It's objective evidence of the condition. The court then went to going into how their doctors reviewed the case, about not so much looking as what was in the medical records, what the complaints were, but were pointing to certain things that weren't there, loss of range of motion or functional strength that weren't even, usual normal symptoms of the condition itself. And it's funny because even today I looked over a denial letter, a Prudential denial letter for a case that we took a call on earlier this week. And I couldn't help but laugh to myself because everything that the court was attacking Prudential on, I'm reading this denial letter, and everything in this denial letter is what they wrote in this denial letter for the most part, that the court ripped apart, saying, how can you require this of it? So it's just amazing how there's always a running theme, and even though in the case Cesar discussed, where you have a large verdict against them, it's like they don't learn from their mistakes. They figure, we'll just keep doing it because we're sure not that many people will really fight us.
Well, I heard you say it in your case, Cesar, and I heard you say it as well, this objective evidence. It's like Prudential's obsessed with trying to look for objective evidence, and their claims handling people are trained to say, well, you don't have any objective evidence, so we don't think you're disabled. Well, the reality is that you don't have to have positive findings on an MRI or an X-ray or a blood test or a CAT scan or something like that in order to be disabled. And Prudential has been told hundreds, if not thousands of times by courts across the country that you can't deny every single claim because there isn't objective evidence. And the sad thing is that, especially with orthopedic, let's say spinal conditions, the statistics are, especially from a recent study out of Harvard, that 85% of the people who go to doctor with some kind of spinal complaint, the doctors can't tell you the exact objective cause of that condition. That doesn't mean that you don't have the pain that you're saying you have. So you need to be able to work with your treating physicians to be able to show what your restrictions and limitations are, even if you don't have strong objective evidence.